Hello, I am Jenny Lynn Lawrence and I serve as the Montezuma County Court Judge. In this video, I am going to explain the basic process for conducting a criminal jury trial. I'll begin with a scenario for you to consider. Yesterday, you were sworn in to your new post as County Court Judge. This morning, you are giddy with excitement and anticipation, arriving to work early. Settling into a piping hot cup of courthouse coffee.
This is, excuse me, a damn fine cup of coffee.
Your court clerk informs you that you have a jury trial scheduled today and that the jurors will be arriving in 1 hour. Concerned but unruffled, you think to yourself, this is county court, right? How tough can a jury trial be? I mean, you were an accomplished litigator before your appointment, right? And the attorneys will know what they are doing, right? I just have to manage the process. Right.
Am I right? I said, am I right?
A few minutes later, your clerk lets you know that the attorneys have arrived and would like to meet you before the trial starts. A nice gesture indeed, so you invite them back into chambers, at which point you realize you haven't been in law school in a very, very long time. Speaking of law school, counsel informs you that they are not members of the bar but are actually practicing under the Student Practices Act. Not to fear, they are expecting their supervising attorneys to appear in person at any moment. And even if they don't, counsel has immediate access to their supervisors via instant messaging. And you wouldn't happen to have an extra telephone charging cord, would you? It is at this point you tell yourself. Hopefully, before you took this job, someone let you know that it often feels like you are spending as much time teaching as you are judging. Hopefully you are okay with that. While the scenario I just provided is a bit exaggerated, it is played out in county courts across Colorado nearly every day. And fortunately, when you do find yourself facing similar situations, you'll have everything you need to successfully manage your courtroom. Let's review a few of those resources now. With respect to courtroom procedures, everything you need to know can be found in Title 16, Article 10 of the Colorado Revised Statutes, Rules 23, 24, 26, 29, 30, 31 of the Colorado Rules of Criminal Procedure, and the Colorado Jury Instructions Criminal, or COLGIS as we know them. You can find the Colorado Revised Statutes and Rules of Criminal Procedure in Westlaw. If you prefer a printed format, most courts have copies on site. With respect to COLGIS, you can locate an online version on the Judicial Net website. In addition to these resources, I have also included a script that I use when I conduct a trial. This script is primarily a compilation of various COLGI instructions. Of course, there is no one way to conduct a trial. You may use the script as it is or modify it to suit your own personal style. Now that we've discussed some of the resources available to you, let's return to the scenario and conduct your first county court trial. In Colorado, every defendant has a constitutional right to a jury trial for any criminal offense. If that person is accused of a misdemeanor, they have the right to be tried by a jury of 6. Individuals accused of Class 1 or 2 petty offenses have the right to be tried by a jury of 3 if a demand is timely made. You'll begin the trial with introductory remarks to the jury. This will include a brief introduction of the case, parties, and counsel. Following introductions, Criminal Procedure Rule 24 requires judges to explain to prospective jurors in plain and clear language the grounds to challenge for cause, a juror's duty to volunteer information that would give rise to a challenge for cause, the identities of the parties and their counsel, the nature of the case, and the general legal principles applicable to the case. Rule 24 also requires the judge to ask prospective jurors about their qualifications to serve as jurors. The purpose of this process is to identify any jurors who must be released for cause. Rule 24B sets forth a list of reasons that jurors can be dismissed for cause. Most are relatively straightforward. The most frequent challenge for cause is that a juror exhibits bias for or against either side that would prevent the juror from rendering a fair and impartial verdict. Rule 24 also requires that the parties or their counsel have an opportunity to question jurors. This typically occurs after the bailiff calls the jurors to the jury box. Of course, before you begin the trial, you would have determined how many prospective jurors you intend to call for questioning. For a panel of 6, I would start with 12 prospective jurors so that each side can exercise 3 peremptory strikes. If you decide to seat an alternate, add 2 additional prospective jurors to allow for an extra peremptory strike for each side. As the bailiff calls jurors into the jury box, instruct them where to sit. For appellate purposes, it is important to keep track of which juror is which, so the jurors need to be seated in the order in which they are called. Criminal Rule of Procedure 24A3 allows the trial judge to impose a reasonable time limit on voir dire. A Colorado appellate case, People v. Rudnick, held that a court may impose time limits as long as they do not interfere with the defendant's right to a fair and impartial trial. Criminal Rule of Procedure 24A3 also allows judges to use poster boards, juror questionnaires, and other methods to assist in jury selection. For example, a poster board may assist in obtaining basic information such as juror's name, occupation, and interest without having to ask the same questions of each prospective juror. Questionnaires, on the other hand, can be helpful in identifying topics that jurors would prefer to discuss outside of the presence of other jurors, or to identify topics that jurors are so passionate or emotional about that their response might taint the rest of the panel. After the attorneys have questioned the panel and all cause challenges are resolved, the attorneys must be given the opportunity to exercise peremptory challenges. The prosecutor exercises the first peremptory challenge, and then counsel alternate until all challenges have been exercised or waived. In misdemeanor cases, each side gets 3 peremptory challenges, 4 if you choose to seat an alternate. For good cause, the court may allow additional peremptory challenges to either or both sides. During peremptory challenges, an attorney may raise a bastion challenge. If that occurs, the court must undertake a 3-step analysis. Number 1, did the defendant present a prima facie showing that a peremptory was exercised solely on the basis of race? Number 2, if so, did the prosecution offer a race-neutral explanation for striking the juror? And number 3, has the defendant shown purposeful discrimination? After the jury is selected, read the list of jurors who were selected and thank and release those who were not. You will then administer the juror oath. After the jury is impaneled, you may decide to take a recess before beginning the trial. If so, and you allow them to leave the courtroom, please provide the instruction in Colgy B2 that informs jurors not to discuss the case or to do independent research on their own. Before the trial begins, explain to the jurors how the trial will be conducted, how to properly use writing materials, how they can submit questions to the court, and how jurors are expected to conduct themselves during the trial. If you anticipate conducting bench conferences during the trial, and bench conferences are often necessary in county court, provide the explanation provided in Colgy C4. This will help the jury understand what is happening when the attorneys are at the bench. The prosecution will then call its first witness. Throughout the trial, you will administer an oath to each testifying witness. After the first witness is sworn and testimony begins, your primary role as a judge is to listen and rule on the evidentiary issues. When I am on the bench, I always keep a copy of the Colorado Handbook on Evidence nearby. I found it to be an excellent resource. While listening to the testimony, I like to take notes that I can refer to later when I need to make evidentiary rulings. I'll also refer to these notes following a defense counsel request for judgment of acquittal at the close of the prosecution's case. In general, I like to provide 2 recesses, one 15-minute break in the morning and another 15-minute break in the afternoon. I generally schedule about 1 hour for lunch. At the time you call your first recess, provide the jury with the recess instruction found in Colgy C12. You will then provide a similar instruction each time you take a break. In addition to the jurors, the court must also administer an oath to the bailiff prior to the first recess. As I stated earlier, there are additional courses available regarding evidentiary decisions you might make during a trial. I do, however, want to mention one issue in particular that frequently appears. That issue is whether to admit evidence of a defendant's previous crimes, wrongs, or acts in the case before you. The analysis required to decide whether other acts' evidence should be admitted is very case-specific and usually is decided prior to trial. If you determine that other acts' evidence will be admitted, be prepared to give the jury a limiting instruction regarding the appropriate use of that evidence. In addition, be prepared to instruct a jury to disregard certain statements that could eventually prejudice a trial. The use of these instructions, both of which are available in Colgy, can be the difference in having a case overturned as opposed to it being harmless error. At this point, let's assume the prosecution rests its case. In many cases, defense counsel will make a motion for judgment of acquittal. If you deny the motion for judgment of acquittal, the defense will begin its case. At this time, you must provide the defendant with a courtesy advisement informing him or her of their right to testify on his or her own behalf. This decision is solely the defendant's to make. The courtesy advisement assures that the waiver is voluntary, knowing, and intentional. You must make the courtesy advisement outside of the presence of the jurors. While they are still out, ask the defense whether it will be presenting any witnesses. If the answer is in the affirmative, bring back the jurors to hear the defense case. If the defense states that it will not be calling any witnesses, bring back the jurors so that the defense can rest its case in the presence of the jury. After both sides have rested their case, the trial court has a duty to properly instruct the jury on all matters of the law. This is a critical step. The failure to do so constitutes reversible error. You'll begin the jury instruction process with a conference, which is on the record outside of the presence of the jurors. Criminal Procedure Rule 30 requires that you allow both parties to make objections to the instructions before they are given to the jury. Parties who fail to request or object to instructions waive that issue for appeal. A number of cases, including People v. Nunez, have held that a defendant is entitled to a theory of defense instruction if there is any evidence in the record to support the theory. The trial court must cooperate with the defendant to correct or draft a proper theory of defense instruction. Once the jury instructions are finalized, ask the bailiff to return the jurors to the courtroom. At this point, you will read the complete set of instructions to them. You will also provide them with a copy of the final jury instructions for deliberations, along with all of the exhibits that have been admitted into evidence. Similar to the first recess, before you release the jurors to begin their deliberations, administer the oath for the bailiff. At times, juries may have a question regarding either the evidence presented or possibly the jury instructions you provided them. In this situation, the jury will give a note to the bailiff, who will bring it to you. Juror questions must be in writing, with copies provided to the attorneys for each side. Remember, any communication between the judge and the jury must be made in the presence of the attorneys or with their knowledge. Rulings regarding juror questions are always on the record. I have included a juror question form that you may find helpful in the materials for this video. The verdict in a criminal case must be unanimous. If jurors are unable to agree on a verdict, you can provide a supplemental instruction, which in general reviews the deliberation process and gives suggestions for reaching consensus. You may be surprised at how often supplemental instructions resolve deadlocks. However, if your instruction does not result in a unanimous verdict, you will have to declare a hung jury, and the prosecutor will need to determine whether to retry the case. The bailiff will notify you when the jury has reached a verdict. At this time, assemble the attorneys and the parties in the courtroom. Ask the bailiff to bring in the jurors, and once they are seated, ask them if they have reached a verdict. If the answer is in the affirmative, have the bailiff deliver the written verdict to you. Before you read the verdict, ask the defendant to stand for the reading. After you have read the verdict, ask counsel if they want to poll the jury. If either party makes the request, you will ask each juror if this is his or her verdict. At this point, the service of the jurors is complete. Prior to releasing them back into the public, provide them with the mandatory discharge instruction found in Colgy E25. At this point, the jury is allowed to leave the courtroom. Depending on the circumstances, you may want to meet with the jurors in the jury room to thank them and give them certificates for their service. Jury trials are a wonderful opportunity to demonstrate the judicial process, procedural fairness, and to provide access to justice to members of the community who are often otherwise not in court. Unpredictable issues will arise during jury trials. Fear not. Even if you, like me, serve in one of the 80% of Colorado counties where there is only one county court judge, many of the county court judges across the state are very helpful. Our county court email listserv is a great resource for you. I encourage you to sign up for that so that you can reach out to your distant colleagues when unique issues arise. Oh, and about that Student Practice Act issue. While we would all prefer to have the supervising attorney in the room, the supervising lawyer is only required to supervise the intern to the extent the supervising lawyer considers necessary. And yes, counselor, I do happen to have an extra phone cable in chambers. I'll get it for you right after I finish this excellent cup of coffee. Good luck, everyone.